wanted to run Mr. Carrim's businesses in his absence. Now, if you look at which paragraph is it now? Let me see. Yeah, I think it's 20 something. Content of 25. Oh gosh, I've lost my place now, but you will all know what I'm referring to. I just have page 25 now. I would imagine. I doubt that it's there, but maybe it is. But the point is this. The deponent to Mr. Carrim's affidavit, the founding affidavit says, I do not know the auditors of Mr. Carrim's affidavits. I think I can mention that it's his wife. What the ruling says should not be mentioned are the names, I think, and other identifying features.
He also has two, so
one of the wives is the deponent. Thank you. So that's the wife. She says, I do not know. And she says, nobody else knows. So this means the virtual PA, who I assume that as a PA, she must be working very closely with Mr. Carrim. And the fact that she even assisted very closely when the bank account or bank accounts were being closed shows the proximity. I do not see the basis on which Mr. Carrim, with regard to who the auditors are, would have been cagey about that information. Not to the PA. I do not see how he would have been. Also, I may not be able, because I do not know the historical involvement of the person now running the businesses prior to him doing so after appointment. I do not know his historical involvement in the companies. But point is, once involved, what would be so difficult in him getting information with regard to these two issues, who the accountants are, and even getting copies of the financial statements? Just what would the difficulty be? Also, this person who's now running the businesses is not the only person. There are other people who have been in place working in those companies. That information cannot reside in Mr. Carrim's head only. I find that very, very difficult to understand. In fact, I want to say this or suggest this to you, Mr. Pramit. You probably are aware of the Gauteng High Court judgment in the case of truth verification. If I'm not mistaken, I think it was written by an EL of AJ, not the old freaky EL of JP. And the principle enunciated in that case was later made or adopted by the Supreme Court of Appeal. But the point is this, and perhaps let me clarify upfront, that principle relates to respondents who make fanciful or patently false statements on affidavit. And that authority, jurisprudential authority, exists because on paper, where you do not test the testimony of witnesses in a witness box, it's very difficult for us to say that person is not telling the truth. But the usefulness of this authority is this. It says, if what a witness says is either fanciful or patently false, it should be rejected out of hand and on paper without the need for oral testimony. So even if, as I say, this principle has been used in respect of respondents, I do not see why it cannot apply to applicants as well. Where am I going with this? I feel as I sit here, subject to what you say, that the idea that nobody within these companies, in particular the person now running the businesses and this PA, nobody can furnish this information. Nobody knows anything about this information. Subject to what you say, to my mind, this appears to be patently false. Your comment?
Natal Scrap Metal and Oxford University Press also endorsed that proposition.
Yes.
On consideration of the Plascon-Evans test. So I don't know if those were the SCA authorities you had.
That would have been a movement or a development on the
Indeed.
Plascon-Evans.
No, but I know the proposition that you're making.
Yes.
Can I direct your attention to paginated page 74, particularly paragraph 40.1, as it relates to I'm using this word in inverted commas, an inference that is perhaps being made about the role and level and intensity of the EA or PA or whatever she's called, and the extent to which they might have business knowledge. And the starting point was, and Chair quoted it, was her involvement when the banking accounts were being closed and so on. With all due respect, I would suggest that 40.1 attenuates that, because it speaks to the very limited and I'm going to say rubber stamp, and you'll understand why when you see that paragraph, that rubber stamp manner in which she acted. So I'm not sure, with all due respect, in terms of what is in front of you on the evidence, that she does as intensive a role as perhaps Chair was suggesting. Obviously, Chair will draw his own conclusion.
She open quote, managed the replacement, close quote. That's an advised.
And all I point out is paragraphs 51.1 and 51.2, particularly the last sentence on 51.2 on paginated page 351, because that in part speaks to Mr. Carrim and the ability to obtain that information, and why even what has transpired before transpired in the way that it did. Insofar as the other individual which Chair mentioned, which is back at page 24, paragraph 67.3, if I'm not mistaken.
I think, was it not also 71?
Yes, no, 71 as well. That was on page. That was on page 25.
I meant paragraph, not page. Paragraph 71.
Paragraph 71, page 25.
Oh, okay.
Which speaks to the same individual that is mentioned in 67.3.
Okay, yeah.
Yes. Again, all I would say regarding this expansive role that he's playing or he's not playing is look at the fifth line in that paragraph 67.3, starting with "he does not make." And I would say that sentence is a direct answer to the Chair regarding what he knows or doesn't know or couldn't know. In particular, that
Mr. Permit, providing information has nothing to do with making strategic decisions and new business decisions. It's historical information.
Yes, indeed, which is why the sentence I was going to direct you to, Commissioner Khumalo, reads in terms, given his age, he does not possess the institutional knowledge of the businesses that resides with my husband. So even if you're interpreting that first sentence against me about providing information not being strategic decision-making, which I can accept, the second sentence in particular speaks in terms to his ability to provide the information or otherwise. If you reject the explanation on paper, that's what you'll do, but that's the evidence you have in front of you. So also insofar as the same individual is named at paragraph 71, page 25 is concerned, you have to read those two things consistently with all due respect, which says that the individual concerned is doing nothing other than acting in a holding pattern or in a holding capacity, but doesn't have the institutional knowledge going backwards and also doesn't have the strategic insight and knowledge going forwards. But I accept, Commissioner Kamalo, that might be an unsatisfactory explanation.
You have not answered the second part of my issue, which was, how can it be that within these institutions, all of them, there is not a single person who knows something about the accountants or auditors? How can that be? How can that be? How is it that this information resides only in Mr. Carrim's head?
I want to choose my words carefully because I'm not going to give evidence as to why that is or isn't the case. But I think it was Commissioner Baloy, you'll forgive me, on a previous occasion when Mr. Carrim was testifying, there was a debate between Commissioner Baloy and Mr. Carrim about how particular decisions are made or not made, and are there proper books of account, and what's the regularity of what's going on inside this business from a corporate perspective. And Mr. Carrim at that time did not say much other than to say how it appears in front of you is what it is. And without putting words in his mouth, all I will say is that businesses operate how businesses operate. They sometimes operate imperfectly. They sometimes operate less elegantly than they should operate. Whatever inference you want to draw from that, you will obviously draw, but the fact that it's not so elegant and bookkeeping or company board resolutions are not maintained in the way that the Companies Act wants them to be maintained is the very basis that most of us have a job as lawyers, because these things happen in the real world in the way that they happen. So I can't answer with a positive version as to what the chair puts to me, which is how is it that it can only be one or should there be others? I have no instructions in that regard, but having regard to what has previously occurred, where Mr. Carrim was put under some pressure, and I say that respectfully, put under some pressure to account for his business operations, which appeared to be less than perfect. He himself couldn't address that in any great detail other than to say that the businesses were and are what they are. And that's as far as I can take it, Chair. I mean, yeah, I'll leave it there.
Can you please assist me? I wrote only paragraph numbers of the doctor's report. Where does it start? Please assist me. I want to take you somewhere there.
Sorry, Chair, can I ask for a clarity? Is it one of the doctor's reports or the affidavits?
The affidavit, the very first one, not the supplement.
Paginated page 30, Chair.
30.
Mr. Carrim here seems to stand at odds with that, and the Commission must take whatever decision it wants to take regarding how it deals with Mr. Carrim in circumstances where it has direct evidence in front of it explaining his non-attendance, as it were. The last 2 points I'll make, and it is really the last 2 points, I'm 1 minute over time, is that there are many new allegations that are introduced in the answering affidavit of the Commission. And you know that on the papers, and particularly in the correspondence, I'm going to use my favorite A word again, there's a statement made about trial ambush in the sense that not the entire case is sought to be answered is made clearly for Mr. Carrim and his legal team and the deponents on his behalf to answer, and then they are ambushed after the fact to say that you've failed to answer this or that you're being deliberately misleading or inaccurate, whereas there are innocent explanations for these things. And if the Commission just showed its hand earlier, then it could have been dealt with earlier and we wouldn't need to go 17 rounds in exchanging affidavits and supplementary affidavits because we'd know the case to meet. Chair, you'd remember you said to Mr. Chaskelson the last time, put it on a piece of paper, those questions you want answered that were supplemented by Commissioner Khumalo. It's the same complaint with all due respect that we shouldn't be drip-fed information. We should know what the Commission has in mind so we can be helpful to the Commission in answering whatever we can, whenever we can. And lastly, may I just say that on the issue of the relief, the terms of the relief are obviously to be finalized, but on the underlying request for the postponement to a specified date or to some other date is ultimately unopposed. And that's Mr. Carrim's submissions in 1 hour and a bit. Thank you, Chair. 1 hour and 3 minutes.
Oh, thank you very much, Mr. Premier. Let me just take you to page 24.
I'm there.
Yes. Please read paragraph 67.2. And after that, 67.3.
Yes.
And and also go to 71. Read 71. I'm not reading these because...
I understand why.
Yes.
Sorry to interrupt, but what page are you referring to?
25.
I said 24 initially, and then it's 24. Page 24 was the first reference.
67.2.
Paragraph 67.2. And then 67.3. And then I was moving on to the next page, 25, paragraph 71. Now, I want to ask a question that relates to the information that has been asked for repeatedly, which is the name or names of the auditors / accountants of Mr. Carrim's companies. That's number one. Number two, the financial statements of those companies. That information was asked for a long time ago, I think in March already. I think initially when Mr. Carrim was testifying here on the 8th and 9th of March, I think, and he promised or undertook to furnish that information. In fact, I think in respect of the auditors, he furnished a name of an entity that eventually denied that it was auditing any of his companies. But subsequent to that, that is the oral undertaking in open session, there has been engagement on that issue, and Mr. Chaskalson has repeatedly made the point about this information continuing to be outstanding and not being furnished So it's something that's been out there in all of our minds. Now, I refer you to these 3 paragraphs to make the point that, 1, the person mentioned in 67.2 is Mr. Carrim's PA. And she's even described as his quote-unquote virtual PA. Quite importantly, here's what is said about her. It is said that when Mr. Carrim's bank account or bank accounts, I'm not sure whether it was more than one, was aware in the process of being closed by F&B, this virtual PA played a very crucial role in that process. So it seems to me that this is someone who is closely involved in Mr. Carrim's affairs. Now, the other person mentioned in the other paragraphs is someone very close to Mr. Hassim and someone who has in his...
Mr. Carrim. Not Mr. Hassim.
Oh, I'm so sorry. I'm sorry, Mr. Hassim. And it's someone very close to Mr. Carrim and someone who
expressly dealt with in that same affidavit at, I see Ms. Madlanga is marking paginated page 51. For example, he doesn't deal with it in express terms, but he's talking about in paragraph 71 on page 51, he's talking about less intrusive formats of engagement and his ability to manage the downstream consequences of the format ultimately chosen as a consequence of what the commission chooses to do or not do. This paragraph admittedly is talking about, in part, the in-camera question, should it be open or should it be closed? But it's an answer to you, Chair, about the extent to which the doctor's position is not to say, you know, I am the block, so to speak, and if I say no, it's no. The doctor's position is to say that I must be consulted, and if I can facilitate something which is not clinically detrimental to my client's, my patient's current position or future position, then I would have to give medical advice in that regard. So it's to say that it's not perhaps as blunt as the way in which the chair was positing it to me.
Now, exactly on what you said last. My question relates exactly to that. If in a sense, even if qualified, the doctor is not altogether rejecting the idea of interposing another doctor, what would Mr. Carrim's position be? And I think that's the point on which you already said you have no instructions.
Yes.
Okay. If we were to say, please get instructions, by when would we get a response on that?
I can't commit because it would have to be relayed to the 2 individuals who would then have to engage with Mr. Carrim when he's available and then have to come back to us as the legal team. As you know, one of the issues is that in present circumstances, we don't have direct access.
But I would imagine, on my understanding of the protocol, the existing protocol, surely there must have been a good few interactions following that protocol. I would imagine that should give you an idea of possible time frames.
No, because in as much as I thought advocates were busy and have busy diaries, I've never dealt with medical professionals whose diaries are even more challenging than ours. And that's why, for example, some of our papers reached late because of when we could consult with the medical professional in particular concerned. Can I say this? In principle, on what's in front of you and what the doctor himself has said, there should be no objection. But that's obviously subject to his ability to speak on behalf of Mr. Carrim with or without Mr. Carrim's consent. Whilst maybe my learned friend is on her feet, so to speak, proverbially, maybe what I can ask is Mr. Bismillah, who's sitting behind me and from my instructing firm of attorneys, can try and get in touch with our other attorneys and the relevant individuals to try and take a specific instruction on what Chair has put to me. That's the best I can offer in the circumstances.
Yes. I must make the comment that what you've just said now is quite useful, which is that there is no in principle objection to the idea.
Well, because from my reading of what the doctor has said, is his opposition, in inverted commas, was on the unilateral imposition of a third-party medical practitioner. But the doctor has himself spoken about less intrusive means in a multitude of manifestations. And if the doctor interposing in respect of a third party to obtain voluntary consent, whether it's given or not given, is within the basket of those less intrusive means, as I see it, because it's not the compelled examination. And so that's why I say, in principle, I don't understand that could be an issue, but I will ask Mr. Bismillah to get the specific instruction.
Thank you. Please continue. Are you moving on to another point?
I see Commissioner Beloy.
Yeah, before you move on, let me just clarify. You and the chair seem to be of a common understanding of what the doctor is saying. So it may be I misunderstand. I'm looking at reading from 73.1 up to 73.3. I understand the doctor to say that there must first be engagement with him on these medical issues. And if we are not happy, and I'm reading now at paragraph 73.2, what is clinically objectionable.
May I ask for the page, please, Commissioner?
Sorry, 52.
Thank you, 52.
Commissioner. 73.1 up to 73.3, but the clarification that I would like to have is because of what he said in 73.3. He says a properly constituted assessment